I have records of the conversation and my employer showing that I was forced to do the task while the male employees were not forced or asked. A lot to unpack here. This is one worth at least getting a consult with a lawyer for. When it comes to employment law, no question is too small. Today we're answering more of your important questions right from the comments section. This one is from our post, "Your employer may be analyzing your Slack messages. Is that legal?" The question is, if there's an investigation going on in a company, can they use Teams conversations and text messages to gather information for the company's legal team? The short answer is almost probably, certainly yes. I mean, I guess there may be limited circumstances depending on what your work environment is, but unless you've signed some agreement that these are private to you, which I think would be pretty rare, then these are the company's property and they can go through and look at them at will and absolutely can use it for the company's legal team. So that's why you should be, the old saying when email was somewhat new, you shouldn't write something in email that you wouldn't want to see on the front page of the New York Times. Same thing for here in a Teams. You don't want to say anything in a Teams conversation that you wouldn't to be used against you or somehow might harm you. So the short answer is yes. Here's one on our post, "Suing your employer, you just need one good claim." Question is, I was recently forced to resign for a Texas-based employer without giving a reason after 10 months of employment. Not only that, but they also demanded that I pay back full amount of a sign-on bonus and relocation allowance per the offer letter. I'd like to investigate the legitimacy of repayment and force of resignation. I'm sorry that you were fired after 10 months. In many cases, this is a contract that you have with your employer for relocation and sign-on bonuses that they can recoup them, which means they can go after you for them, which can be very painful. Not only have you been fired, but you've got to pay these back. So I would go back and look at your offer letter. If there's language in there that says that you have to repay that if you're fired after a certain amount of time, then you may be on the hook to pay it. If the offer letter is silent, then you might have an argument that your employer can't go after you for these things like a sign-on bonus and relocation. So it just depends on what their offer letter said and what any other contracts you may have signed with the company. If you signed one, you may be on the hook for it. If you didn't, you may be able to argue that this wasn't that wasn't part of the deal. That wasn't part of the contract that you repay these things back. And in any event, these can often be negotiated. So whether you do it alone or with an attorney, even if the company can enforce them, they have to go to court to do that, which is expensive for the company. So you may be able to negotiate those numbers down, but good luck with that. I hope it works out for you. Another one from "Suing your employer, you just need one good claim." What to do if a company forces you to do something against your will after making a prior complaint about the discomfort and workplace safety? I have records of the conversation and my employer showing that I was forced to do the task while the male employees were not forced or asked. I hope this holds up because I have a manager who constantly singles me out in front of everyone for the smallest things, and I have to keep a smile and keep working. So a number of things going on here. I mean, if your manager is forcing you to do things and not asking, it sounds like, men in the company from doing the same thing, then that could be illegal. That could be workplace harassment because it's based on a protected category, right? Based on your sex, that you are female and not a male. That's a protected category, and if your manager is discriminating against you on that basis, which based on what you put here sounds like maybe happening, then you may have a claim. In terms of being forced to do things that are in violation of workplace safety, it depends on what those are. You might have a claim that you could bring to OSHA, the Occupational Safety and Health Administration. So there's the federal OSHA, and then there are state analogs. So state OSHAs, they may be called something different within your state, but basically enforce workplace safety issues. You may have something that you could bring to them. I mean, this could be a retaliation too for raising this issue, which could be a separate claim. So this is one, a lot to unpack here. This is one worth at least getting a consult with a lawyer for. And the other one is, can I sue my employer for telling me that I have to shave my head or at least make it super short where it's off my forehead when I am a housekeeper, cleaning rooms, etc., or houseman or groundskeeper? So can they enforce basically kind of a dress code, or this instance, how you wear your hair. If it's a uniform requirement and it doesn't conflict with some kind of religious belief, your employer can enforce those kinds of requirements. The employer can't pick and choose, right? So the employer has to apply these uniformly to the employees and can't just say, okay, you have to keep your hair short, but you can, wear your hair in a ponytail. But usually these are enforceable. So unfortunately, you're probably going to have to do that unless it's against a religious belief. Your questions help everyone learn. So thank you for sharing them. If you're still curious, leave us more and we might tackle yours next.